afternoon, everyone. Thank you for joining us for today's online talk, which we will start at 3 o'clock. For those of you who were here earlier, thank you for waiting patiently. And now, as we begin, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Again, welcome everybody. Thank you for joining us today. Today's online talk is entitled Managing Misconduct in the Workplace, and I'm sure that this would interest many of you who have signed up. As a form of introduction, my name is Tommy Wong. I'm a Senior Associate with Wong Associates, and I'll be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Wong Associates is a mid-sized law firm that was founded in 1985 by Dr. Ma Wing Kwai. Our able team today comprises 37 lawyers and a support team of 28. Dr. Ma today is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. Now, the firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution team, including litigation, adjudication, and arbitration. We also have a dedicated employment and industrial relations team, whom are here today with us, and a department focused on servicing the needs of individuals and families. Now, today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, about 10 over years ago, some of which were also broadcasted live. But with the COVID-19 and the MCO, we have shifted online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and also in-house counsel. Now, before I continue, please be reminded that this online talk does not constitute legal advice. In the event you require specific legal advice to your specific or particular matter, please contact us independently for a complimentary legal consultation. Details will be given at the end of this talk. Now, we have two speakers for today. Allow me to introduce our speakers, Naveen Joshua Solomon and also Jasmine Wee. Naveen is a senior associate with the firm who was admitted to the Malaysian bar in April 2017. He is a senior associate in our dispute resolution, employment law and industrial relations, and also individuals and families departments. His areas of practice include the laws on employment and industrial relations advisory and litigation matters, as well as general litigation, which includes contractual disputes and debt recovery. Now, moving on to the next, we have Jasmine Wee. She's a senior associate in our dispute resolution, corporate, individual and families, and employment and industrial relations departments. She graduated with a Bachelor of Laws from the University of London, and her areas of practice include the laws on employment, corporate litigation, strata management, adoption, citizenship, and immigration. And she regularly provides advice to clients on various strata management tribunal claims. Now, we have 5 top points in our online talk today. Now, Jasmine, we will first be speaking on understanding misconduct, recognizing early signs of misconduct, and developing clear policies and procedures. Thereafter, our second speaker, Naveen, will be speaking on disciplinary actions and also legal compliance. And with that said, I will pass the floor on to Jasmine Lee. Thank you very much.
Thank you very much, Tommy. Hi, everyone. Good afternoon. So as my colleague Tommy mentioned, I will be taking the first 3 top points. That is understanding misconduct, helping you recognize early signs, and also developing clear policies. So when it comes to understanding misconduct, of course, it's pretty self-explanatory. Misconduct is an employee's reactions that violate established rules, policies, or ethical standards set by an employer. So it can either be an act or omission which violates or affects the employee's expressed or implied obligations to the company, and it relates to an employee's duties both at work and also their position outside of the premises of the office. So any behavior affecting a company's image or reputation can be defined as falling under misconduct. So it spans from a spectrum from both minor infractions and also very serious misconducts. And of course, the punishment, which my colleague Naveen will get into in more detail later on. But it spans from a spectrum and it can be corrected through various manners, training serious breaches of company policy, which warrant immediate action, such as termination. So we'll start by defining misconduct. And misconduct, by definition, of course, describes employee behavior that's inappropriate for the workplace and also negatively impacts the employee's work, environment, or peers. So some types of misconduct can be corrected through training and one-on-one discussions. Others require a more firm response. So resolving misconduct, of course, promptly is essential for protecting employees, promoting teamwork, upholding best practices, and also avoiding litigation, which I'm sure most of you intend to do. Managing misconduct also reflects your values as a leader, and it also impacts the company's mission. So here we have a case called Azhari Shahrom against Associated Pan Malaysia. So just to give you a little bit of insight into this case, both claimants in the case of Azhari Shahrom were employees of Associated Pan Malaysia Cement, and they were both officers of a union. So the day in question, what was alleged against them was that they had breached their fiduciary duty between the employer and employee because they had not shown up to work. The first claimant told his supervisor that he was feeling ill and was going to apply for medical leave, but instead chose to attend a picket line. The second claimant just did not show up to work. So later, upon investigation, it was discovered that the first claimant had in fact convinced the second claimant not to show up to work in support of the picket line and also tried to convince other employees. Later, after their termination, they filed this suit and tried to say that their termination was without just cause and excuse. And the courts found that the company had provided sufficient evidence to show that the claimants had indeed breached their fiduciary duty to the company as he tried to convince other workers not to go to work. So here the courts held that it is right that the association between an employer and an employee is out of necessity, is fiduciary in nature. There has to be mutual trust and confidence between both parties. And if one doesn't act or commits an omission, which is an act that is not done, that is inconsistent with that fiduciary relationship, then that act or omission will be considered malified. And then we have the case of Akira Sales. Here, the respondents were dismissed without a domestic inquiry being held. So they were directors, and they had failed to reply to a show cause letter which had accused them of misconduct. As directors, they had operated an account without the company's knowledge and authorization as well. So they had co-signed on operating this account. And when they filed this suit, the industrial court had held that their termination was in fact without just cause and excuse. And of course, the company appealed, and the claimants were claiming that their act was not considered to be legal. Operating this account, even though it was without the company's approval, was not an illegal act, and thus it could not have amounted to misconduct. So the appeal courts had disagreed and had held that misconduct does not need to be considered illegal under the eyes of the law in order for it to be considered misconduct. And some more definitions here, more PC definitions from Professor of Law Alfred Alvins in his book Employees' Misconduct, which defines misconduct as the servant is bound to give faithful personal service to his master, and as a consequence, to refrain from any course of conduct and the natural tendency of which must be to injure the master's trade or business. And in the English case of Pierce against Foster, if a servant conducts himself in a way that is inconsistent with the faithful discharge of his duty in the service, it is misconduct which justifies immediate dismissal, right? So moving on to types of misconduct, of course, the list is non-exhaustive. Many things can be considered misconduct, but these examples that I'm about to give you are just the more common forms of misconduct that we come across. And the most common one, of course, is tardiness, attendance, and mannerisms at work. So all these things could consist of being late to work persistently, but without any justification or without informing any superiors. Absenteeism without approval. Absenteeism would be considered absenteeism if you do not show up to work for more than 2 days in a row without any justification. And of course, running personal errand during work hours. I'm sure some of us have been guilty of this, but of course, try not to overuse this opportunity, I would say, or benefit. And disrupting others in the workplace could range anything from harassing your coworkers, being loud in the workplace, or even being intoxicated in the workplace, which would make others understandably so uncomfortable. A negligence of duty at work, which would result in losses to the company. It doesn't matter if the losses are big or small. And of course, insubordination, refusing to follow instructions, refusing to work with others. Those are just a few. And of course, disregard for company safety and security measures. So this is especially important where in industries that operate with heavy machinery, rules are there for a reason, and it's to ensure that everybody working around this heavy machinery is, of course, safe. And I'm sure sometimes some people think it's okay to cut little corners. You've done it once before and probably wouldn't happen again, but please don't do that. The rules are there for a reason. If you get yourself in trouble, if nobody gets hurt, no harm done, but your employer will still get in trouble. So of course, there's non-compliance with security measures, tampering with any safety devices or machinery, complete gross disregard for company safety procedures, which would endanger others. As I mentioned earlier, being under the influence while at work, and also falsification of records. And then, of course, you have a third popular option, which is confidentiality breaches. And this includes sharing private information about the finances of the company, business practices, customer relationships. So this would mean while you are working as an agent of the company, you have access to, let's say, client contacts. And when you leave to a new company, or perhaps you choose to start your own business, so there are some people who go into these company contacts and they try to poach customers. So that would be considered a confidentiality breach. Failure to return any company property when requested, and also willfully damaging or vandalizing company property. Improper usage of company IT facilities. So by this, I would mean using, say, your work laptop to download any unauthorized applications, or maybe you're streaming movies online and then you end up downloading a virus. Confidentiality breaches are especially, they're serious in all fields, but they're especially serious in healthcare fields, especially when you're dealing with such sensitive information. So of course, there's IP theft and fraud, which would really affect the reputation of the company. And now we have some case studies for you. So we have the case of Dahlia Ashari against Malaysia Airports, Niaga Sindran Berhad. So here the employee had committed a serious misconduct. It's a tale as old as time. So you apply for MC and then they instead go on holiday. And unfortunately for her, she had decided to post all about her holiday on her social media accounts. And of course, she was discovered and later on dismissed. When she filed her claim, she claimed that she took leave. It is her business what she does on her personal time. And the courts held that her dismissal was with just cause and excuse. Then we have the case of Zuhilmi Fauzi against MISC Berhad. Here, the employee was dismissed because he had been using morphine during work hours. And while he was well aware of the company's drug policy, and he had even signed a waiver to that effect, however, he had claimed that it did not affect his work performance. He was high functioning. He did what he was supposed to do. It was just unfortunate that he was caught doing drugs while at work. And the courts held that his dismissal was more than fair, because failing a drug test is a major misconduct and is clearly inconsistent with the fiduciary duty relationship between an employer and an employee. So an employer here is well and within their rights to expect that you show up to work sober. In the case of Sebastian Matthias Bohem against Siemens Malaysia, Sindran Berhad, here again the employee was under the influence while at work, this time with alcohol, and unfortunately was misbehaving at the hotel bar and was even sexually harassing and assaulting hotel staff as well as guests. So the employee then argued that it was after work hours, while he was on the work premises, he was drinking after his shift. and therefore he could not be punished for what he does on his own personal time. The courts once again held that his dismissal was done with just cause or excuse. So as I mentioned earlier, misconduct does not only consist of things that you do in the office. It also counts when you are misbehaving outside of company premises, because how you are on the outside is a reflection of the company. So by his actions, the employee had then shown himself to be a staff of the company who could not be trusted to uphold its values. So the employee here had potentially exposed the company to great legal risk and also harmed its reputation. In Mattel Tools against Anwar bin Hassan, once again, employee being under the influence at work and was misbehaving at the company's annual dinner. So here, no guests were involved, but it was all internal office staff. So dismissal was again held unfair because the senior manager, who was also drunk and misbehaving, was simply let off with a warning. So we'll get into this a little bit later on. There's a certain principle that this is named after. And the employee had misbehaved. However, somebody else with a higher position was not punished. My colleague Naveen will get into this further later on. When you are thinking of a punishment to give off to a misbehaving staff, the punishment has to fit the crime. And of course, you have to be consistent in enforcing the rules, and there's no cherry picking. Otherwise, there is no purpose of having clear rules and policies. In the case of Nyam Gyok Moy against Pacific World Destination East, an employee here was dismissed due to insubordination. So the superior had given her instructions to make payment for a corporate expense and make adjustments to the company budget. And for some reason, she took it upon herself to think that this was not something that she needed to do, or rather something that was appropriate for her to do. So she decided not to. And to make matters worse, she had written a very scathing email to her superior saying that she would no longer be reporting and she will be operating on her own volition. So even though she was found guilty of insubordination, the industrial court held that the punishment of termination was too harsh a penalty. A warning would have sufficed because she had been working for the company for 20 over years. So a single act of insubordination in a perfect record of good behavior was not proportionate to what was alleged. Here, under section 15 sub 2, it said that the contract of service deemed to have been breached if a person is continuously absent from work for more than 2 consecutive working days. So this is what I was talking about earlier when I mentioned what would constitute absenteeism. So a serious misconduct is a gross violation of discipline, which would then justify an immediate dismissal. So this is the case of Pan Global Textiles against Bang Tek. And here, the principle of condonation. Okay, principle of condonation would mean if you encourage this behavior. Say you have an employee that is misbehaving and you have excused this behavior more than once, or rather quite often, and you cannot then later decide that you want to fire this employee for misbehaving when you have continued to let this behavior go on for longer than necessary. So with the principle of condonation, I would just like to point out that it does not apply to employees and it only applies to employers. So here in the bottom case called Chong Fui Tong against Sena Die Casting Industries, here an appellant was a director of the company, and he, after a series of arguments, was then advised to resign from his position. He then took it as him being constructively dismissed by the company, and the industrial court had awarded in the appellant's favor. Of course, the company was not happy and decided to appeal the judicial review the matter. And then the appellant had briefly mentioned during his cross-examination that while he had considered himself to be constructively dismissed from the company, he continued to sign checks for the company as a signatory, not as an employee, but simply as a person that was authorized to sign. So it was out of necessity and he had to do it. So the company used this against him to say that if you are still signing checks for the company, you could not possibly have been constructively dismissed. Here, the courts held that the High Court's reasoning here that the concept of condonation applied equally to a workman was misconceived. The concept of condonation could not be applied to employees in that it could not apply again to employees, because condonation, if proven, is a concept that is to be used adversely against an employer who takes no action against an employee after becoming aware of the misconduct and then later seeks to rely on the past misconduct which is deemed to have been forgiven or excused or condoned. So the concept of condonation should not be confused with a waiver and acceptance and acquiescence to describe the employee's reaction to the employer's conduct in the context of constructive dismissal. So the employee's conduct of not protesting against the employer's breach or of continuing to work for a considerable period of time, even though the employer's breach is deemed to be an affirmation or acquiescence to the varied contract of employment. So the employee's conduct is not an act of condonation of any sort. Rather, the employee's conduct is said to be a waiver of his or her right, or an acceptance or an acquiescence to the employee's reputory breach. Now we are going to talk about recognizing early signs of misconduct. Of course, it is very subjective. You would have to exercise this at your discretion. But one of the more common examples we would give here would be increased absenteeism or tardiness. I mean, regularly missing work, regularly arriving late. Even if they provide a justification, if you are noticing that an employee that usually shows up to work on time is missing a lot of work or arriving late and appears to be disgruntled, this could be a sign of underlying dissatisfaction and also disengagement, or perhaps they are intentionally trying to avoid certain people or certain responsibilities at the office. So withdrawing from team interactions is also a very common one. This is reduced involvement in team activities, whether it is about work or whether it's about after office activities with your colleagues. Avoiding collaboration can signal a lot of issues. Any negative attitudes or defensiveness, especially about their work, and they're receiving or perhaps giving frequent complaints, they're getting defensive about receiving constructive criticism. Any hostile attitude towards feedback can also indicate frustration or resentment. There's, of course, drop in quality or quantity of work. And if there's a noticeable decline in performance, so this one, for any superiors here or HR attendees here, or perhaps our employers, we have to be very careful about this one, because there is a difference between poor performance and perhaps deliberate intentional misconduct. So it could be that there's a skill gap issue. So we would have to discover whether that is the issue that is causing the quality of work to be less than satisfactory, or is it an actual problem of misconduct? So of course, avoiding accountability and delegating excessively, these are for employees. This could be a sign that they do not want to take responsibility for the work that they are doing. So by delegating excessively, then someone else will be taking the fall rather than them. Also, it could be attempts to evade scrutiny. So you only stick to things that you know, so you don't get in trouble. And then when you are asked to do things that are perhaps new or of a challenge to you, then everything messes up. Now we have unexplained expense claims or missing assets. So these we see more commonly in employees that are perhaps more upper management level staff, those who have access to company accounts, company finances, or anybody that makes claims from the company. So this you would see in frequent vague or inflated expense claims. So sometimes they are justified. Certain companies do allow for very good benefits, but oftentimes people do misuse these. So that is something to look for as well. And abusing company time or resources, that is engaging in personal tasks during work hours, as I mentioned earlier. Misusing company tools, let's say you're provided with a company car. Perhaps the terms are that you're only meant to drive to a certain place, to office. Perhaps you have gone beyond your miles or beyond the allocated gas fees, anything, could be anything. It's also spending excessive time on non-work related activities. So one very common point about this is people who play games while they are working in the office, or reading books, reading comics, reading magazines, all those kinds of things. All this can point to early signs of misconduct, and it is best to nip it in the bud early rather than later to avoid falling under the principle of condonation. Changes in interpersonal relationships. This is where you see, this is more common in staff between upper management and also lower management. So of course, the forbidden office romance. This can result in favoritism or conflicts of interest, signs of favoritism or blurred boundaries between, but not even just office staff, between vendors, clients, other team members, can lead to conflicts of interest and potentially unethical behavior. And when you're having interpersonal office relationships that are inappropriate, there's a power imbalance there. And of course, when things are good, then perhaps the work does not suffer. But when the couple has an argument, then we know the rest of the story. So frequent conflicts or complaints, when employees or clients report an increase in conflicts, inappropriate use of language, hostile interactions, and the indication of interpersonal issues that may escalate if they are not addressed. So these are just a number of things that you have to look for. And so circumventing rules is a pretty obvious one. So regularly avoiding established principles, cutting corners, skipping any compliance checks. This is especially important, again, for people who work in the industry that operate heavy machinery. Definitely nip that in the bud early. So because it indicates a willingness to disregard rules, which will potentially lead to some serious misconduct. So a lack of transparency in communications as well. Employees that withhold any information. Of course, some people are just more secretive than others. Don't pry into the lives of your employee, but if it is work related, as an employer, you are entitled to ask. And if your employee is not willing to answer you, then that could be a sign of a brewing problem. So workplace ethics and values disregarded. So a complete and gross disregard for company policies. So I will get into this a little more later on about developing clear company policies. So people who regularly ignore policies or they express disdain for them, it indicates a lack of respect for authority or workplace ethics. And clearly, if you're upset about a couple rules, then you must not have any intention of following them. And also, of course, a low engagement with compliance or ethics programs, not participating in ethics training, avoiding compliance sessions. I know sometimes they can be a little boring. Nobody wants to willingly go for these sessions, but they are important, and it is a good thing for you to attend ethics training in order for you to keep up with any sort of changing rules and any workplace regulations that you should take note of. This is another one, reports from colleagues or whistleblowers. So oftentimes when misconduct occurs, the first person to notice would be a peer, people who work with these sort of people. And when they notice red flags early on, the company should make an effort to ensure that there is a safe and clear channel in order for these whistleblowers to go to in order to report this misconduct. Some people may be very uncomfortable. It's already an uncomfortable situation, so it is best to make it easier for the reporter. So taking such reports seriously can also be vital. So sometimes they turn out to be nothing, but better safe than sorry. Any anonymous tips or whistleblower feedback, they're always worth investigating because they could reveal a lot more. Any personal, financial, emotional strain. So this one, we do have to be careful as well to not pry too much into your employees' personal lives. But any sign of financial hardship or emotional stress could lead to possible misconduct in the sense of maybe performance will be poor, maybe they will be resorted to doing illegal things to solve their issues. Just make sure you check in on your employee to ensure that everything is okay. If you can provide assistance, then do try to help them out. Any unusual workplace patterns or extended work hours or odd schedule changes. Some of us intend to work late. Sometimes most of the time it's for the reason because you simply can't get work done during the work hours, but we have come across people who do this in order to avoid their teammates or rather avoid supervision because everybody will be asleep by then. Nobody will be around to hover. So it could be an attempt to hide misconduct. That is something to be careful. Frequent closed-door meetings or private conversations, especially in offices. We notice these days there are a lot of offices that are more an open office concept. So if you feel the need to constantly whisper about with your conversations, then clearly something is not right there. So we do understand that sometimes you do have to have private and confidential conversations, especially with upper management staff or even just between your teammates, but you do it sparingly. So upper management, so it's not just about employees being lower level employees being marked for misconduct. It can also happen in upper management. So what we see here, the most common pattern is when upper management staff or supervisors, they set really unrealistic goals and they are saying the justification is that it acts as a motivator or a benchmark for employees to achieve these goals. However, when your goals are unrealistic and you make it impossible for somebody to achieve them, it then creates an imbalance in the workplace and then it fosters a really negative environment. So you could have your employees possibly stepping over each other just to achieve their goals. There'll be a lot of unnecessary backstabbing, and which would then lead to a lot of unethical practices in order for them to be the one to solve the task. So yeah, there was quite a lot, but those are just some of the examples of how you can recognize early signs of misconduct. But of course, everybody is different. Every office is different, and the people you work with best. So just keep an eye on them and remember to check in. So while now that we come to developing clear policies and guidelines, so this is all a precursor to the rules that you set in order so they can't stop misconduct from happening, but you have to at least inform people of what would happen or rather what the rules are. So this is important because clear policies and guidelines on workplace misconduct, they protect company reputation, they maintain a standard of conduct for all employees, and it also fosters healthy work cultures. So it encourages a culture of accountability and respect and provides proper avenues to report misconduct on all levels. I would just like to note that while it's important to have policies and guidelines, it is of course best not to be excessive, not make rules that are impossible for people to follow or not to nitpick at things. Of course, it differs from industry to industry. But of course, the basic rules about workplace dress, workplace behavior, all those are okay. So any specific rules for the industry, feel free to include them, but again, do not be excessive. So as we outline different types of things that you should include in your policies, what is definitely important is to define and also to categorize what would constitute a misconduct in the workplace. So as you are outlining types of misconduct, do make sure to define clearly what constitutes a misconduct, especially in your workplace. So these categories should, again, the list will be non-exhaustive because misconduct can consist of a lot of things and you can't exactly provide for that many specific circumstances, but do include minor and major misconducts. So these can range anywhere from absenteeism, fraud, theft, which is one of the more major ones, and minor ones could maybe be profanity in the workplace, things like that. Provide some examples of misconduct as well, as I was mentioning earlier. So proper education about the categories of misconduct is very important. If people don't know what is a misconduct, then they wouldn't know if they have done something wrong. Make sure that these rules and regulations are easy for people to understand and for enforcement as well. So this is what we mean. Of course, it is always best to consult a legal professional while you are drafting and creating these policies. Some smaller companies, perhaps it's just a handful of employees. If you can afford it, definitely seek help from a legal professional, but of course, there are some basic rules that you can find out there that have been in general practice for very long. You could come up with it on your own, but just make sure the rules are easy to understand and the words used are not convoluted or confusing. So differentiating between policy violations and performance issues. This is what I was mentioning earlier when I said you had to determine whether is it a skill gap issue or is it an actual issue. So when clarifying these two things, of course, the difference would be any sort of behavioral issues and permanence issues due to skill gaps or underperformance. If it is something that is due to underperformance or a skill gap issue, then my suggestion would be perhaps to provide any training or support, then see if the employee would improve in their performance. So now coming to clear code of conduct, of course, highlight the expected behavior and values of the company. So here, developing a code of conduct, sometimes it's known as an employee handbook, but some companies, they tend to separate a code of conduct and an employee handbook. So it is your choice on which one to have, but we definitely highly recommend it. So emphasizing values and principles of the employees that they are expected to uphold. So more common ones would be to respect each other in the workplace, to have integrity in the workplace, to be honest, and also, of course, to comply with laws. So this code of conduct usually would include things about how you're meant to behave at work or even outside of work, and how you, as an agent of the company, how you have to carry yourself when you leave the doors of this office. So addressing specific situations, including having guidelines for specific situations that are relevant to the company's industry, such as how employees should interact with clients, how they should handle conflicts of interest, and also how they are meant to use company resources is very important. One more is to outline disciplinary measures, and you have to tell your employees that if they misbehave, what would happen, basically, what is to be expected. So stating disciplinary processes for various misconduct levels, this will, of course, depend on how severe the misconduct is. So you could either give verbal warnings, written warnings, you could suspend them, or you could terminate them. So as I mentioned earlier, the punishment must fit the quote-unquote crime or the severity of the misconduct. And of course, emphasizing consistency. The communication that whatever this policy is, it has to be applied fairly and consistently across all levels of employment, not just to lower level staff, because you have to promote trust and accountability. Designating reporting channels, specifying to employees, making it clear to them how they can report misconduct, or whether it's of themselves, their peers, or perhaps their supervisors. And of course, the safe channels usually people do this through is through either their direct supervisors, any HR representatives, or they even have an anonymous platform for employees to put in their complaints. As for whistleblower protections, this is more so for perhaps staff that are wanting to make a report against a person who is of a much higher level of employment than they are. So usually this involves corruption and things like that. So I'll clearly outline the protections for employees who report on misconduct. Do not punish employees for reporting misconduct. And also show a commitment to confidentiality and assurance against retaliation, because we find that a lot of people tend not to say anything out of fear of retribution or anything else. So encouraging early reporting is also very good. Make it very clear to them that early reporting is any potential issues is encouraged instead of discouraged, and it can also lead to a more positive resolution. Define an investigative process as well. Describe how misconduct reports will be handled, include any initial fact-finding, interviews, evidence collection, and determination of outcomes. Assign responsibilities. Please identify who will conduct investigations. Usually the person that does this is HR, of course, but if you don't have one, you can hire an independent investigator. Always ensure fairness and prevent any conflicts of interest when you are investigating any sort of complaints. And by that, the person involved, if upper management is involved in the complaint, then do not have them investigate the alleged misconduct itself, or commit to confidentiality as well. And again, emphasize that all investigations are to be confidential and respect all parties involved. Now, anti-harassment and discrimination policies, this relates to anything from bullying to sexual harassment. Now you have to specify policies on harassment and discrimination. You have to detail what constitutes harassment or discrimination, and also make it very clear that there is zero tolerance for such behaviors in your workplace. So anything to do with confidential information, this would fall under data and information security. And this, again, is pretty self-explanatory in itself. Just make sure that your employees know that it is not okay to unauthorized sharing, having data leak, or cyber misconduct. And of course, you have substance abuse policies, and make it very, I'm pretty sure this is, again, pretty self-explanatory. Just to make sure, do not show up to work under the influence. So outline any support options available if you do have any employees that are struggling with this issue. Regular training sessions to promote awareness, conduct training on misconduct policy, ensure all your employees understand what is to be expected of them, behavior, outcome. Ensure that employees know that they can report their concerns. Do not shame them for reporting any concerns. Frequently communicate with your staff. So periodically remind employees that of this policy. You could have internal newsletters. It could be just a one pager or even a half page. Could even be through emails, posters, or any staff meetings. And the most important one, in my opinion, would be leadership involvement. Of course, you lead by example. And if leaders are openly supporting policies, they're demonstrating the importance of compliance, they're also following the rules to a T, then your employees will follow suit, I believe. Of course, regularly update your policies. The law is always changing. Make sure your HR staff or whoever is handling the policies and guidelines are aware of this, and to update any outdated policies. Soliciting feedback from your employees, asking them what could be done to make the workplace a safer environment for them is also very good. Monitoring your policy effectiveness. So track trends in misconduct. You can find plenty of these reports, especially from HR experts or even legal professionals as well, to assess the policy's effectiveness. And you can adjust your training or disciplinary procedures if needed. Providing easy access to your policy, of course, is also a very important one. If nobody can access your policies and your guidelines, then there is not much point. Again, translate your policies if you need to, especially if you have a multilingual workplace. And these are just some examples that I can give to you. Every policy can be different, but this is a very basic one of things that you should include. Of course, introduction purpose, scope of your policy, defining things, as I mentioned earlier, code of conduct, behavioral expectations, listing out the disciplinary process and the consequences, describing where they can find reporting channels, and also talking about whistleblower protections, investigation procedures, special misconduct policies, policy reviews, and of course, update your policy review. So that will be my segment of the talk today. I'm going to hand it off to my colleague Naveen for his segment of the talk. Thank you very much.
Good afternoon, everyone. Thank you, Jasmine, for that comprehensive explanation on the first three talk points, which was understanding misconduct, recognizing early signs of misconduct, and also developing clear policies and procedures. As my colleague Jasmine has explained, with regards to the understanding of misconduct, early signs, and the policies, we can now look into the types of disciplinary action that you can impose on those employees. First off, of course, as any misconduct definitely will be met with disciplinary actions. But the most important thing for you to understand would be to know why these disciplinary actions are actually being taken. So I'm not going to go into too much detail on this, but just remember that the reason for disciplinary actions for these misconducts is actually to address behavioral issues and to ensure that these behaviors are not repeated, not only by that particular employee, but also the employees around. Because organizational standards are definitely important, and also accountability and promoting respectful work environments, and like I said, to deter future misconduct, not only from that particular employee, but also from others. You then, with regards to the documenting process, one key thing that I can highlight to all employers is to make sure all investigations, communications, everything, keep it documented. Because when it comes time, or when any employee takes you to task in the industrial court, the court will look at whether or not you have kept all of this documented. Any types of meeting, make sure that all these documents are signed not only by the employer's representative, but also by the employee. And in relation to investigating a particular misconduct or a few misconducts together thoroughly, a few steps are required in that, amongst them being gathering evidence. When I say gather evidence, you need to collect the relevant documentation. When a complaint is made or when you discover that a certain employee, they're making some mistakes, you are to investigate them by gathering this evidence. You also can conduct interviews by speaking not only to the accused employee, but also to speak with the relevant witnesses and to get a comprehensive understanding of the situation. In the investigations that is carried out by the company, you also have to ensure that there is fairness and also confidentiality, because while you investigate, there may be things done not only by the employee, but also the people who are supporting the employee, and then evidences may differ, and then your outcome will be affected as well. So handling investigations discreetly and impartially is vital to protect the privacy of all parties that are involved. You also need to assess the severity of the misconduct. In assessing this, there are a few things to consider as well, one of them being the intent and impact. It's also vital to check whether a particular misconduct was committed accidentally or intentionally. This is very important because, of course, an intent you might not know at the very first place, but to discover it along the way, you would know whether it was in fact accidental or intentional. Past behavior also plays a massive part, as in any industrial court case would have taught you that unblemished record goes a long way, but at the same time, a record with similar misconducts or other disciplinary actions also invite contributory negligence on the part of the employee. Then we go into determining proportional consequences. As the doctrine of proportionality, it has been written in every industrial court award in relation to misconduct. When I talk about proportionality, you have to remember in mind that any act, misconduct, when it is met with any type of punishment, it has to be proportionate. Any punishment has to be proportionate to the actions that have been carried out. So you have the verbal warnings and the written warnings. So when you look at under verbal warnings, we also put that document for future reference. The common mistakes that certain companies do is that when you give verbal warnings, it's just a manager giving a verbal warning to his underlings and nothing is documented. But later on, this verbal warning is actually stated in the cost papers. And that is where it is difficult for the company to prove that, in fact, these verbal warnings were actually issued. So even though it's verbal, document the whole meeting to ensure that you have the record of it and also that it is signed by the employee as well. Do not let it only be signed by the representative of the employer, but make sure it is also signed by the employee. So verbal warnings do require documentation as well. As written warnings, it's for repeated and moderate offenses. Also in written warnings, make sure that any act or misconducts are specified. You have suspension and termination as well for misconducts which are serious. You can allow for suspension throughout the investigation period. You can put them in half pay. Of course, you can go through that in the Employment Act, so it provides for that. And for termination for gross misconduct, you have under Section 14 of the Employment Act, which I'll go through later. You have the instances of gross misconduct whereby you have fraud, violence, and severe harassment. Of course, make sure that every termination that you carry out, the legal requirements are followed. You have also a more lesser form of punishment where you can offer them, the employees involved, you can offer them training or counseling, and you can also provide them with supportive resources. Of course, this is not the normal measures that are taken, but there are companies who have taken this route, and it has been proven to be effective for not only the company, but also the employee, because it allows them to go navigate through their working, through their employment with whatever that they're going through personally as well. You have PIPs and regular follow-ups. PIPs, what I can say is, of course, you need to set reasonable and achievable goals for the employee. You can't put in something that is difficult to be achieved within 1 month. The most reasonable one will always be between 3 months to 6 months. And this outline should be clear and it should be notified to the employee as well. Then we go on to domestic inquiries with regards to investigations. Of course, domestic inquiries, they look for truths, they look for facts, and all the circumstances concerning the charges. The process begins after the issuance of the show cause letter. The domestic inquiry is often, it's not often, it's always created or run by the employer themselves. So once the response to the show cause letter is obtained and the company is not satisfied with it, the employer can commence the domestic inquiry. It must be borne in mind that DIs are merely it's a fact-finding exercise. It does not decide on the action, but it merely finds whether there has been guilt on the side of the claimant or the employee, and they may recommend any actions to be taken. Ultimately, the decision lies with the company. As I said earlier, Section 14 sub 1, domestic inquiry is not provided for by the Act itself. The words used are due inquiry. Due inquiry can also mean show cause letter, anything that involves the response of the employee and the putting forth of allegations by the employer. So there has to be two sides communicating on that particular allegation or notice of allegation, so anything related to the allegation. You have Section 20 sub 1 as well, which of course states that any termination needs to be carried out with just cause and excuse. I'll go into cases as well. I'll keep it brief. In the case of Gianna Yo Sina against Virgos Oils, you have here that the Act itself, it was held in the case that the Act itself does not provide what is due inquiry. In some cases, even discussing with the employee in question can be considered as due inquiry. Like I said, there has to be a back and forth between the employer and the employee. That can also constitute due inquiry. Show cause letters, the guidelines for this, allegations should be clear and precise. Referencing employment contract, because there are duties also provided for in the employment contract, confidentiality, non-compete or whatever, everything needs to be referenced, what duties have been breached. And if you have a company handbook, a company policy in place, refer to them as well in the show cause letter. And with regards to deadlines, if you're having 10 allegations, please do give some reasonable deadlines to the employee to reply. So if you're giving them between 5 to 10 allegations, I always recommend at least 5 working days to show that when it goes to court that the company was actually acting in good faith. And if there is a suspension necessary, it's provided by the Employment Act itself. It shall not exceed 2 weeks, should be half wages. And if the employee is found not guilty, the wages should be paid back to the employee. As if the explanation is satisfactory, the punishment, there is no punishment. And if there is unsatisfactory explanation, you can proceed with the disciplinary action, a notice for the domestic inquiry, and suspension if necessary. A notice for the domestic inquiry should also, again, be precise. And one of the more important things that I would like to point out here is the possibility of having a representative during the domestic inquiry. So if, for example, if an employee, he has a union, so he most definitely would be allowed to have a representative there as well. Of course, it is subject to the terms of the collective agreement, but an employee should also be allowed a representative as the company himself has a prosecuting officer. I've outlined the most important parts with regards to a domestic inquiry. I'll go on with the panel. As you can see, the panel members will maintain in an odd number so that there is a majority decision in case there are any differing decisions. Panel members should be more senior. The PO and the investigating officer should not be on the DI panel, and they also should be of different departments in relation to the panel. There are also cases where you can get someone from the outside to be on the panel as well, an experienced industrial relations consultant or someone like that. The hearing, of course, I'm sure you're familiar with, but the findings, I just want to particularly emphasize on the findings. The panel members are to decide whether the employee is guilty or not guilty. They are to recommend disciplinary actions. But the panel members do not decide on the action. It is the company who decides based on the findings of the panel members. Again, it's in relation to the domestic inquiry. The investigating officers must not be related to the incident or the individuals involved. A right to be heard is definitely important, because when the minutes or the recording of the DI comes out and the employee was not given a right to be heard, that can show bad faith on the part of the whole DI, and the court will just proceed to hear the matter afresh. When we look at case studies, when this claimant was dismissed from the employment after the company's board of inquiry proved 2 charges, matter was referred to the IR court in favor of the claimant. The company then applied by way of a judicial review to quash the award. The High Court upheld the decision of the Industrial Court. Then further, the company appealed to the Court of Appeal. The Court of Appeal also upheld the decision of the High Court and the Industrial Court. In here, the 2 charges that were put forth against the claimant, there were no particulars of date and place of the offense and time. A defective charge for want of material particulars is void ab initio. It's void from the very beginning itself. So this is why how important domestic inquiry findings and how even the notice itself should be particular and specify everything. This case as well, the domestic inquiry was held to be improperly conducted because one of the two panel members was in fact the investigating officer. It shows the duplicity of roles there. You have the case of Abdul Ghani where the company witness, it's quite strange here because the company witness admitted that he was the investigating officer in the DI and the prosecutor. Furthermore, the company witness also signed the appellant's termination letter. On appeal, it was definitely true that the company witness one had indeed played multiple roles. So there is a conflict of interest on his part. Here, the fact remains that the company carried out matters that were against the company's handbook. Despite responding to the show cause letter, he was terminated from employment. There was no disciplinary action. There was no official inquiry. Warnings also were not recorded. Even though if it's verbal or written, it should be also stated there, and the time allowed for improvement should also be stated there. The company itself admitted that there was verbal warning, but no record of any verbal warning. No warning letter was given to the claimant, and the company did not carry out a domestic inquiry. Again, in relation to the case of Pelabuhan Tanjung Pelepas, a domestic inquiry was held. However, the DI panel found the employee not guilty. In this case, interestingly enough, the company decided that despite the finding of non-guilty of the claimant, the company decided still to terminate the claimant. So this was definitely unfair, and the court itself stated that if the domestic inquiry found the employee not guilty, he may not be terminated by way of Section 14. The management cannot substitute its own opinion in place of the facts that were found by the domestic inquiry. So again, the DI panel finds whether the employee is guilty or not, recommends the punishment. However, the company can decide on the punishment still, but not even when the employee was found not guilty. I'm going to go to the last point with regards to legal compliances, just to outline the number of laws that are available that you should comply in carrying out your disciplinary actions. First one, I'm going to start with the Employment Act, as there were recent amendments to this act, and previously it only applied to employees below 2,000 ringgit, and now it applies to all the employees who are employed under a contract of service. So it is very important for all your HR personnel to be well versed with the Employment Act right now. You have the Section 14 sub 1, where the 3 types of punishments are there, but these punishments only may be imposed after due inquiry. So again, like I said, due inquiry, remember, it's not necessarily domestic inquiry. It's as long as both parties have exchanged communications on the allegations. The employer may terminate employee services following a fair inquiry. Again, fair inquiry, not necessarily a domestic inquiry, but to ensure that both parties have been heard. A dismissal without notice for gross misconduct, the examples of it, theft, dishonesty, and violent behavior. So these are gross misconducts, and even though your contract of employment provides for notice, but if you can prove that these serious misconducts have actually taken place, you can dismiss the employee without notice. Again, now with Industrial Relations Act 1967, you have the unfair dismissal claim. So if you feel that you were terminated improperly, and even because of the process, the investigation process that was done in bad faith, do feel free to file a complaint to the Industrial Relations Department. You can go on with a meeting between both parties, and you can try to settle it as well. You also have the Occupational Safety and Health Act. It was recently amended. Please do comply with the recent amendments, which also include a health and safety coordinator in your workplace. And there have also been instances recently where the OSHA department has put out a list for the employers or the companies who have not complied and been fined, a hefty fine. I believe it also amounted up to 100,000 ringgit. The list is also available in the OSHA website. Whistleblower Protection Act, for those employees who have reported a complaint in good faith, they are legally protected from termination or other forms of retribution. Of course, you have to investigate everything that comes from this channel, but make sure that person is protected and everything else investigated accordingly. Lastly, severance benefits by way of the employment termination and laying off benefits regulations, it does not apply if the employee is dismissed for serious misconduct. Of course, if the employee goes on to challenge the termination and he is found to have been dismissed without just cause, he can then apply for it in the channels provided. With that, I end my part of it. Do remember to always comply with the prevailing labor laws, and also before you carry out any action, make sure all investigations are documented. Thank you. I'll pass it back to Tommy now.
Thanks, Naveen. Thanks, Jasmine, for the wonderful insight into the topic managing misconduct in the workplace. So now we will take questions from the participants who have entered their questions into the Q&A chat box. So I think we can start off with the first one. Anonymous attendee asking, what is the proper way to dismiss an employee with behavioral issues, i.e. rude and abrasive to colleagues in other departments in written and verbal communications, and also rolling eyes at superiors, but they are performing their work to standards? Now, in this case, what would be the best or proper motions to go through to dismiss the employee for misconduct? Perhaps, Naveen, you might want to take this question.
Okay, yeah, thanks. Thank you, Tommy. And also thank you to the participant for posing this question. I think before I answer the question, I think before an employer starts, and I believe that before an employer starts an investigation, they shouldn't start it with a preconceived notion that he should in fact dismiss the employee. The proper way is to investigate the truth to these issues, whether they are actually substantiated, gather the evidence, interview the employee itself, and later, if it has basis, issue a warning letter to the employee. In the event that he continues, then a show cause letter can follow. There is no 3 warning letter rule, please. Remember, because I think I wouldn't say that you require 3 warning letters for any particular conduct. But if there is even 1 warning letter and it continues, the employer can proceed to issue a show cause letter. At the end of the day, the employer owes a duty to ensure that the workplace is safe and harmonious. So yeah, to start off by at least issuing a warning letter, and the employee can improve on his behavior. Of course, he's working up to the standard, but if it's impacting others, something should be done, and at least a warning letter or verbal warning can always be issued to the employee. Thank you.
Thanks, Naveen. Second question from one Miss Catherine Lee. She has asked for us to kindly go through and clarify the principle of condonation. Jasmine, you are on mute.
Sorry. Okay, so principle of condonation, by dictionary definition, it just means forgiveness or purposeful disregard by the person that is suffering from the act. It just means that you are treating the other person as if nothing happened. So you condone the behavior. So condonation is a principle in which an employer has allowed the employee to go on with the misconduct for a while, even though they have knowledge of it. So if then the employer would then not be able to punish the employee for that particular misconduct. But of course, the recent Court of Appeal case I mentioned earlier, the principle of condonation is only allowed to be used as a defense by the employee, but the employer themselves cannot use it as a defense. So if an employer wants to avoid this, they will have to show that they did not or would not have possibly had any knowledge of the misconduct prior to them bringing it up.
Okay, thanks, Jasmine. Third question, anonymous attendee. When issuing a warning letter, is it required to be issued 3 times before taking any further action? Now I'm going to jump a bit here and pass it back to Jasmine to catch you off guard a little bit.
Okay, thanks, Tommy. As my colleague Naveen mentioned earlier, there is no three-letter warning rule. So depending on the severity of the misconduct, if it's not that serious, then of course you may have to issue 1 or 2 before you actually take action. What is more important is that once a warning letter is issued, reasonable time must be given to the employee to address these issues and to improve, because you cannot expect an employee to fix problems overnight. If it says something, if your warning letter says that they need to start showing up to work earlier, then perhaps there is something that can be fixed overnight. So the next day they'll have to come to work on time. But for more serious issues, obviously, reasonable time has to be given.
Okay, fantastic. I think there's another question tying into this one that you have mentioned. Now, this anonymous attendee, perhaps they may be the same one or different one, don't know. But this person has asked, if warning letters have been given for different misconduct, i.e. the first warning being absenteeism, and the second warning being misuse of office property. Now, in this scenario, can the employer then proceed with any further action? Back to you.
So if there is evidence that these issues have persisted after your warning letters, then of course you can proceed with further action. Again, what is more important is that in your letter to show cause or your termination letter, make it very clear what they are being terminated for. So if it's a combination of these 2 issues, then say that.
Thanks. Now, moving on, there is another, I think almost all the questions are being asked by anonymous attendees. Quite confusing. Sorry. Okay, now this question is basically, in employee investigation meetings, would it be helpful to have legal counsel sitting in for the purposes of maintaining legal privilege? I think most people would like to hear Naveen's voice, so I'll pass it to Naveen.
Thank you, Tommy. Thanks again for this question. So would it be helpful to have legal counsel sitting during employee investigation meetings? I'm going to take it that you are including preliminary investigation meeting, not only domestic inquiries, but also meetings involving the employer and the employee. My advice would be no, because you would want to show that the employer is actually operating under the assumption that he does not want to terminate the employee yet, because you're still in the midst of investigating. So it's better to settle it internally, like the name would suggest, also domestic inquiry, it's all done internal. But employers are always open to get the necessary advice and also get lawyers to help them as well with regards to the drafting of certain questions or investigative notes. So my answer to that would be, I believe that they don't need to have it, a legal counsel sitting in, as they can always obtain the advice and the necessary help beforehand itself. Yeah.
Thanks, Naveen. Now, looking at the time, we have about 3 to 5 minutes, probably another 3 to 5 questions if time permits. Now, the next question is also from Anonymous. Is it sufficient to issue a show cause letter and make a decision based on the reply of the show cause letter and not have a domestic inquiry? I think Naveen?
Yes. Thanks, Tommy. Again, good question. I would say that it is not necessary to have a domestic inquiry. I think case laws have also suggested the same. The lack of a domestic inquiry is not fatal because the industrial court is allowed to hear it de novo, which is a fresh hearing. So the employer can make a decision based on the reply of the show cause letter. Like I said, Section 14 sub 2 of the Employment Act provides that due inquiry must be conducted. So with due inquiry, all that is required is the communication between both parties, being the employer and the employee, in relation to an allegation. So when the company puts forth an allegation towards the employee, must be afforded an opportunity to explain in relation to the allegation. What happens after that? The company can always decide on the explanation from the show cause reply itself. So that is due inquiry. Domestic inquiry is not mandatory, but of course, having one would not hurt your chances in succeeding. It would go quite a bit of a way to show that the company did in fact do everything that is required. Of course, legally, you have conducted the due inquiry, but at least by practice, you have conducted the necessary. So it is encouraged, but it is not a must. And a show cause letter reply is sufficient for the company to make a decision on. Thank you.
Okay, thanks, Naveen. Another one, can an employee be placed on garden leave after 2 weeks suspension if it's not provided in their letter of award or acceptance, LOA? Back to Naveen.
Yes. So garden leave is not provided for under the Employment Act. Garden leave is often, if you see, it's more towards the higher ups when they are about to leave the company. They're put on garden leave to ensure that nothing or no information from the company is leaked out. So it can be placed subject to the mutual agreement between both parties. If the employee is all right to be on garden leave, it is always all right for the company to impose that on the employee, only subject to mutual agreement. Because this is not even provided for under law. It's just a sophisticated term that has developed over the years to be put towards employees. Yeah.
Okay, we still have time. I think attendees will be quite pleased, but unfortunately, it's also another anonymous. The question is, an employee on 3 months probation has been performing poorly and only keeping silent and saying no comment during meetings. Does the employer need to put the employee on PIP, issue show cause letters, warning letters, etc., in order to justify non-confirmation of the probationer at the end of their 3-month probation? Now, in this case, can the probationer be informed of their non-confirmation at the end of the probationary period without notice? Naveen.
Yeah. So I think I'll start with the fact that probationers and full-time confirmed employees, they enjoy the same rights. Of course, when they go to industrial court, the probationers are only entitled to 12 months back wages, and full-timers, confirmed employees, are afforded 24 months back wages. What you need to understand is, if an employee is on a 3 months or 6 months probation, they have to be afforded the opportunity to complete the 3 months or 6 months. In this case, the question relates to a 3-month probation. They need to be allowed to fully serve that 3 months probation service, and the employer can, in between, they can always inform the employee on what needs to be improved and everything. You need to document all of that. And you don't need to put a probationer on a PIP because, of course, as probationers, they are actually in the period where the employer is gauging their potential, whether they would be a good fit for the company. In the event that they are found not to be a good fit, the company can always take the option to not confirm them. Of course, it would be advisable for companies to at least inform the employee of his shortcomings if it's very glaring or very noticeable. But at the same time, the employer has the opportunity to not confirm the employee because, as the name suggests, it is a probation period as long as you allow the employee to fully serve their probation period. Do not decide to terminate or give notice 2 months. If there's 3 months of probation and you just terminate him after 2 months and allow him 1 month notice, do not do that. Let him finish the 3 months probation and then give any non-confirmation. Thank you.
That was very comprehensive. Thank you, Naveen. 1 or 2 more questions the first one coming from Shirley. If the warning letter has been sent via WhatsApp or email channel, does the employee need to acknowledge receipt of such letter? I will pass it off to Jasmine.
I'm not really sure what you mean by acknowledging receipt of the letter. If you mean they have to reply to the message, then probably not, but at least you have to verify that the employee has read this message, just so you know that they have knowledge that this letter was sent to them.
Thank you. I think in addition to that, I believe, Shirley, you're asking from the perspective of an employer. At least perhaps you could do your own part and safeguard your own interest by following up with the employee and to make sure that the letter or whatsoever contents in there have been actually read by the employee themselves. I think we have one last one before I conclude. I have some news and some feedback forms to give out. So last question, then the lucky lady is Ms. Nurul Aina. The question is, if an employer advises an employee to resign, or rather advised to resign, would that be considered or would that constitute a constructive dismissal? Naveen and Jasmine, whichever one of you want to end it on a good high note, I'll leave it up to you.
I think I'll take this, Jasmine. I think this is a very interesting aspect because case laws have come out and sometimes certain employees or employers, they fail to take note of this. So there's a difference between constructive dismissal and forced resignation. If an employee is asked to resign, forced to resign, and if he doesn't resign, life will be made tough, that's forced resignation. But you have to understand not every such forced resignation also is construed as constructive dismissal. Constructive dismissal, the elements have been very clear. The first part of it, there should be a fundamental breach. When we say fundamental breach for constructive dismissal, over time, what has been established is in relation to your remuneration, in relation to unilateral demotion, and things like that. So the root has to be one that is, the breach has to be one that it goes to the root of the contract. So that is constructive dismissal. And when such things happen, and if let's say your salary is reduced or your position is changed unilaterally, you can't just leave the company citing constructive dismissal. Okay? You have to at least provide the company with an avenue to repair or remedy that breach. If you leave just like that, the company might turn around and actually claim for your notice period. So it's always important to afford the company with an opportunity to explain themselves or an opportunity to repair the situation. So forced resignation, if an employer forces you to resign, the best thing that you can do is to state it in your forced resignation letter. If you were to resign by saying that I resign now, I wish to thank the company for all the opportunities afforded, highly likely the court will say that your resignation letter does not seem to suggest forced resignation, unless you can prove with other factors or like WhatsApp messages or some emails that go to establish the forced resignation. But one must first understand the difference between forced resignation and constructive dismissal before opting for one or the other. Thanks. Thank you.
Thanks, Naveen. Thanks, Jasmine. I think that concludes our Q&A session. Do allow me to make a few announcements before you leave. First, please join us again for our upcoming talk on the 27th of November, which is a Wednesday, and also the 4th of December, 2024, also a Wednesday. Our dear colleagues will be speaking on the respective upcoming talks on this slide. Secondly, please follow our social media and like our social media accounts, and our team will be pasting the links on the chat in this Zoom. And fourthly, next, if you would like to have a complimentary consultation, we do have that option up to 30 minutes, and we could arrange for you to speak with our lawyers. I do see that there were quite a number of questions that were unanswered. Perhaps if you could just drop us an email or send us a text via our phone number or office number or on WhatsApp, then that will be grateful. We'll be grateful, and we can arrange a complimentary consultation with you guys. And also, I believe our backend team will be sending you some feedback forms, and we would be grateful if you could tell us what you thought of our talk. And yes, the link to the form will be posted in the chat if it's not already. Now, to our guests, thank you very much for joining us today. We hope you have found today's session informative and useful. Again, this presentation does not constitute legal advice, and its content should not be relied upon as such. If you would like to have a legal advice coming from us or legal services pertaining to your particular matter, please contact us and we will allocate you and assign your matter to our colleagues accordingly. Thank you very much, and see you at our next talk.